in attendance at this time. Hopefully people will start streaming in. So I want to continue our discussion of contempt of court and deal with those matters which are still to be addressed. I was talking yesterday about the way in which contempt law is applied in practice or should be applied in practice. And one other point I want to make is that it is generally speaking a good idea not to comment on the merits of a pending case in such a way that it prejudices the outcome of this case. Quite frankly, this principle is not, sorry, I'll just put up the full screen. This principle is not as valid in India as it is in countries which have a jury system, because the intention here largely is not to influence the jury. But I still think that it's a good idea. Even with a judge, one needs to be careful, because at the end of the day, if a judge begins to feel pressured, then that's not a good thing for democracy. It's definitely not a good thing for a fair trial. So the best thing is, you can talk about a case, but don't talk about it in such a manner that you effectively imply that the judge has no choice except to act in a certain way. That's what I mean. You can of course talk about the case, even the facts of the case, but not the merits in such a way as to potentially influence the judge. Now, in terms of the prejudice that may be caused to pending trials or imminent trials, there are a number of issues here. In some countries, there is the standard used of substantial risk of serious prejudice. I personally think it's a very good standard to use, because what it means is, the question that we asked about any piece of writing will be, does this piece of writing cause or represent a substantial risk to the trial, a substantial risk of serious prejudice? Now, the important words there are substantial and serious. Not just risk, but the risk has to be substantial. It has to be quite big. And the prejudice that will be caused, or that might be caused, will have to be serious, not trivial or minor prejudice. So that is the standard which is often adopted, and I think it's a good one, and I will elaborate on this when I give you a case or two. There's of course a danger of sensational reporting, which needs to be avoided. So again, even if you want to say something, say it in language that is not sensational. Now I know that that is not advice which editors or sub-editors like, because sensationalism sells. And in those circumstances, if there was a newspaper which produced a report that was in very staid language, then that newspaper is less likely to find favor with readers than another newspaper that might be screaming the same message. So therefore, you just have to make a choice. Those are matters of editorial judgment. Now, another thing which is important is the time and distance between publication and trial. Let me give you an example. Suppose there is going to be a high-profile, controversial case involving somebody who is standing trial for certain acts committed in a certain city at a certain time. If the newspaper or media coverage of the case was extensive in that place and very close to the time of the trial, the chances of prejudice would be higher than if the same media comment was present, let's say, a few months before the trial and not at the venue of the trial. In other words, some distance from the trial. Of course, in one respect, in India you don't have to worry about this principle because, sadly in India, trials take too long to happen. So in any case, automatically there is a distance put between the event and the trial. In fact, many people will argue that the distance is too much, so much so that memories begin to fade. Witnesses can't remember what they saw. But from media's point of view, it is definitely useful, this principle. But I'll also tell you how this in practice has been implemented in India. You know that in certain cases, the trial venue has been shifted. So that if something happens in Ahmedabad, they may say hold the trial in Bombay, or something happens in Madras, hold the trial in Bangalore. Now it's partly because there is a fear of intimidation of witnesses, but also it can happen because there is just too much adverse media coverage in the place where the event took place, and that can prejudice the court. Therefore, let us take it to a venue where the extent of media coverage is less. It can happen. And that is a principle which is seen as conducive to a fair trial. I've already told you about particular dangers with jury trials, and I also told you about the need to avoid the media proclaiming guilt or innocence on the part of the defendants. Okay, in terms of revealing previous convictions of defendants, we did have a discussion about this very briefly earlier, and I think one or two of you thought there's nothing wrong in revealing the antecedents of a defendant. As I said, generally if a case is being dealt with by a judge does have the training or should have the training to put these things out of his mind. But we are all humans. It is very difficult for anybody to completely shut out information about a person's previous record. So if you have someone who has come up before the court on a certain charge, and if it is revealed in the media that this particular defendant has had a string of previous convictions on the same charge or charges, then I think it's reasonable to believe that the judge is going to also be affected by that information. And the principle in law is that a person is being tried only for the offense for which he is before the court. Now, I know that this may cause some difficulties to some of you who may argue that, look, at the end of the day we have to take into account the history of the man, the character of the man, etc. There is a point in time when that happens, and that is made relevant, and that is before sentencing, not before conviction. So the way it works is, if you have somebody who is in front of a court for rape, now if the man's previous convictions for rape are revealed, then there is a higher chance of the man not receiving a fair trial than if those convictions are not revealed. But it is important, if the fellow has convictions for rape before, that he be punished severely for this rape that he has been convicted for. So what will happen is, ideally, his previous convictions will not be spoken about at all, either in the court or outside the court. He will be judged on the merits of what has happened in this particular case. He may be convicted. Once he is convicted, it is entirely open for the prosecution to argue, when the time for arguments for sentencing come up, to show that this man has a string of convictions for rape and therefore he is a dangerous person who deserves to be put behind bars for a much longer time than if he was a first offender. So that is the sort of principle that is being adopted in systems that believe in a fair trial. And of course, there is a need also for identifying potential defendants or witnesses where their identities are at issue. In some cases, the police are not sure about the identities of people who are responsible for a certain crime. So what do? They carry on investigations. If at that point the media starts speculating on individuals and almost saying that so-and-so was involved in that crime, then clearly there is a risk of identification going wrong. So again, you need to be careful when identification is in doubt. There is no blanket ban on the reporting of sensational cases. A point definitely worth noting, because I've sometimes heard students ask me, if the case is particularly sensational, should the media be careful and not report the cases till the trial is over? And the answer to that is no. The media can and should report even on sensational cases, because there is a public interest in the reporting of sensational cases. And I've given two examples there from England, one of which was the case involving a husband and wife who committed horrific murders and buried the bodies of their victims in their own back garden. And this was all revealed many years later, and it became very, very sensational. And there was a huge amount of media coverage of this case. And the court said that's all right, there's no contempt of court, because this is a matter of public interest. The second case is Michael Fagan, which I don't know if any of you remember. If you're slightly older, you remember that about 20 odd years ago, a fellow, an unemployed alcoholic, entered Buckingham Palace. He trespassed into Buckingham Palace and actually managed to enter the bedroom of the Queen. And he sat by the Queen's bed and started a dialogue with the Queen in his own way. And on top of that, he also stole cigars and I think wine from the palace. You can imagine how frightened the Queen must have been in finding this intruder in her midst, but then she is known to be quite unflappable, and she somehow managed the situation extremely well before the security people came and took him away. Now, this also was a sensational case, and remember, these cases are all heard by a jury in England. So, in terms of a fair trial, there were concerns expressed whether this man is going to get a fair trial, because the newspapers then began writing all kinds of things about Michael Fagan, including his past history, the fact that he was homosexual, etc., etc. Now, that meant that there was a risk that the jury, which would have heard his case of stealing wine, would have been ill-disposed towards him. And yet, the court said, no, these cases can be reported and they are of public interest. So, no matter how sensational the case is, it is still possible for journalists to cover the cases. Ideally, of course, journalists should still respect the rule which says, do not reveal a person's previous convictions. I've already told you about the need for the prejudice to be substantial. Now, each case, of course, must be judged on its own merits. Simply because there have been previous publications does not mean that the present publication had exacerbated the risk. So everything will have to be looked at on the facts of each case. And regard, of course, should also be had to the extent of publication in catchment area. Now, the catchment area is the area where the trial takes place. So, in that area, the saturation coverage, then there might be some concerns raised. Of course, one way of avoiding that problem or mitigating that problem would be for the court to move the trial to another city. That happens sometimes because the saturation coverage is such that it might be putting too much pressure on the judge. And care should be taken when reporting confessions made to journalists before a trial. This also is a point worth noting. You know that journalists are quite keen to bring up as much sensational material about a case or a defendant as possible. So, for example, if there is a crime committed and the media get access to the accused person, they may persuade the accused person to confess to the crime. So the accused person may blabber to the media. Sometimes they may boast to the media, depending on the crime, that they did something. Of course, they'll regret it afterwards, but they've already told the journalist. And the journalist might also offer them inducements to speak more than they should. And then this so-called confession is published in the newspaper before the trial. At the trial, the accused person is told by his lawyers to plead not guilty, which means that they are not confessing to anything. But because the confession has already been published in the newspapers, it will definitely have a prejudicial effect on the trial, because the judge has read it, other people have read it. They'll say, what is this? There's an inconsistency between what you're telling us and what you've told the media. Who is to be believed? So there are issues like that. So it's always a good idea not to publish so-called confessions. In this particular case, there was domestic help in a certain household who had confessed to stealing something from the household, and they confessed that is to the media. And as I said just now, when the trial happened, she argued, she pleaded not guilty, and the judge had to then decide what to do with the proceedings, and the court had to let her off because there was a serious problem since the so-called confession had already been published in the media. So sometimes a trial can be aborted as a result of so-called confessions. Now, in terms of deliberate contempt, again, this distinction is not very vital to India, but it's still worth noting. Basically, that there is no pending proceedings, but the situation is such that there is almost inevitably going to be a case. Then you have to be careful about what you say in your coverage of that case. This was a case, the Sun private prosecution case was a situation where there were allegations of a child being raped, and the Crown Prosecution Service, which is the prosecution agency in the UK, decided not to bring a prosecution because they did not have evidence of a kind that would stand in court. This happens sometimes, even if there is a lot of sympathy for the victim. A case can not be brought to court because there is not enough evidence, enough legal evidence. The Sun newspaper, on the other hand, was convinced that the person who was responsible for this rape should be punished, and so the Sun decided to bring a private prosecution. Private prosecutions are very rare, can be done under certain circumstances. So the Sun newspaper, of course, it's quite a rich newspaper, it's got a lot of money. It financed the prosecution, and yet the prosecution failed because the Sun's coverage of the case before the trial was such that the accused could not have got a fair trial. So if you're going to do anything like this, then you better be careful that you don't say anything by way of media coverage that will prejudice the case. You can't have it both ways. You can't also sell your newspaper and then try to get what you call justice for the victim. You have to be a bit patient in these circumstances.
So would you kindly elaborate a little bit on this?
What the Sun newspaper did was,
technically what are you referring to?
I'm referring to a situation where the Sun newspaper wanted to have the alleged rapist punished. The prosecuting agency in the UK decided not to bring a prosecution. Not because they thought this person was innocent, the suspected person, but because there was not the requisite degree of legal proof. What the newspaper did was, it started a campaign in very lurid terms. Of course, the case itself was sensational in the sense that a young person had been raped. But the Sun newspaper went hammer and tongs and started writing a lot of things about the alleged rapist. and also funded a prosecution. Now, before the trial began, if you write a lot of things in the newspaper, it is going to prejudice the trial. And remember, these trials are held before juries. So the jury would have read what appeared in the newspaper. For those reasons, the prosecution failed, because the judge at the start of the trial said the newspaper has written so many things about this defendant that he doesn't stand the chance of getting a fair trial. That is the point I'm trying to make.
That means exactly a trial by media.
Correct.
Producing.
Exactly. If you want to put it in colloquial terms, it is trial by media, which should be discouraged. Okay? That doesn't mean you don't talk about the case. You can talk about the case, but keep it very general. Don't go too deep into the merits of the case. That is the point that is being made here. Okay? What about police appeals about criminals? This is something which also journalists should be mindful of. Sometimes the police themselves ask the media to help trace criminals. They make an appeal through the media. So the policeman call a press conference and say, we are looking for so-and-so in connection with this murder, and we ask you journalists to publicize our appeal. Now, generally speaking, it is not a good idea for the media to identify somebody whose identity is in doubt, because that is risky. You can be punished for trying to influence a legal proceeding. But if the police themselves come and tell you, we are looking for so-and-so, and they even supply a picture of that person and say, please, publish this image either on television or in newspapers, then you are free to do so. No problems. If subsequently any legal issues arise, you will be protected. Why? Because you are following police advice and therefore doing it in the public interest. Discussion of public affairs is a defense that you can sometimes use when you are charged with contempt of court for discussing something which should not be discussed. In other words, in the context of trial by media. So, you would have some latitude in writing about even in cases, even when what you write may have some impact on the trial. But the condition is that the publication should be part of a discussion in good faith of public affairs, and the risk to legal proceedings is merely incidental. I'll explain this by giving you an idea of what happened in this case. English and Attorney General. There was a heated debate in England about abortion, as there is in many countries. In other words, should abortion be encouraged? No, it is legal. Should abortion be made more easily available? Sorry, just somebody tampered with the volume of this. Now it's booming too much. Just keep it in what it was before. Is that okay? Can you hear me now? Yeah, let's keep it like that. So the issue was, should abortion be liberalized? Let's put it like that. And I saw something to that effect in the Indian newspapers a few weeks ago, where the issue was, I can't remember, is it 20-week limit in India?
24 weeks.
24 weeks, okay. Should that be increased? And there was one particular case where there was a very late abortion allowed under the orders of the Supreme Court of India. So that is a kind of issue that was being discussed in England, where the limit is 20 weeks. Now, there are lots of people in England who believe that already the law on abortion is too liberal, that it should be tightened, because they sincerely believe that the life of the fetus is as important as the life of a fully grown person. It is a debate which will go on for a very long time. In the context of that, what happened was there was a by-election to Parliament, and one of the candidates standing in the by-election was a pro-abortion candidate. In other words, he wanted the law on abortion to be liberalized. And one of our newspapers, the Mail, was opposed to that argument. So they published a report. Completely by coincidence, there was a case of of a doctor being prosecuted for carrying out an illegal abortion at that time. Completely a coincidence at the time of the by-election. So the newspaper was carrying a report on the merits of the argument for liberalizing abortion, which, as I said, coincidentally impacted on the trial, because the fear was, or the allegation was, that what the newspaper had written about abortion would have influenced the trial. And this trial is again a trial by jury. In other words, members of the jury would have read the article and thought the worst about the doctor who was standing trial. He would not have got a fair trial. That was the argument put. But when the editor of the newspaper was prosecuted for contempt of court on the grounds that he should not have said what he said in the paper, his defense was, I was not commenting on the case at all. That is out of my mind. I was talking about a matter of public affairs to do with the election. Elections are always occasions when there is a lot of comment from the media, from the general public on matters of public interest. And we were talking about the merits of a particular candidate. So we were saying that this candidate's argument for liberalizing abortion should not be heeded by the electorate. And therefore we were discussing abortion in that context. And it is complete coincidence that there was a trial taking place. And so we should not be held liable for what happened in the trial. And that argument was accepted, because the court said that this article was discussion on a matter of public interest, of a public affair, which in a democracy should be allowed. So you can see sometimes you can use a defense which is beneficial even if there are countervailing factors. So freedom of the press means that discussion of public affairs is a very important aspect of a free media. And so this is again a point worth noting.
So say for instance you have, so very commonly I guess you have letters to the editor, right, where individuals can voice out their opinions and the newspaper publishes it. So in that situation, if say there is a letter which has been drafted in a rather insinuating manner and there is a matter right now that is sub judice, so then can the newspaper, if held liable for contempt, take the defense of discussion of public affairs?
Up to a point. Depends on how the issue is handled. In other words, if the letter writer puts his views forward in a completely unbalanced way, then clearly the editor has to take some responsibility. Because do remember that when you are the editor, you have the right to edit letters that are sent for publication. So you can tone down the language, or you can take out those bits which are outrageous. So as long as you have acted responsibly, I think it is entirely proper for a newspaper to argue that what it did was to aid public discussion on a matter of public interest. Any other questions? No? Okay, let's move on. So that's again something useful for journalists. Court reporting of trials. Now, this is something which some of you asked me questions about. And the answer, the general point is that all fair and accurate reports of ongoing trials published contemporaneously are immune from contempt action. What does it mean? If you, as a journalist, were writing about a trial that is taking place, if you report fairly and accurately about what happened in court, you are exempt from contempt action. Now, why is this important? It's important because sometimes in the course of a trial, things may happen which are controversial. To give you a simple example, there might be an exchange, a heated exchange between a lawyer and a judge in the course of a trial. And sometimes the heated exchange also might include what almost amount to abusive comments against the judge. Can happen. I'm not saying it happens frequently. It rarely happens, but it can happen. Now, if the proceedings involves anything that otherwise would be contempt of court, and you report it, you will still be protected because of this rule. Why? Because you're producing a fair and accurate report of a trial. And the third ingredient for this rule is it should be published contemporaneously, which means you don't wait forever for many days, weeks before you publish. You publish as soon as the event takes place. In the case of a newspaper, it will be the next day. In the case of television, it might be a few hours, it might even be a day later, but not a week later. So, but on the other hand, if your journal comes out only once a month, then it will be a month later. That's fine, but fairly contemporaneously. So that's the principle there.
Sir, you mean all heated exchanges and all fairly and accurately can be reported?
Absolutely,
As far as
absolutely.
possible, verbatim.
Unless there is a specific order expunging certain remarks, which usually doesn't happen, but you are fully entitled. Or you can even say, in the Indian context, there's a very interesting phenomenon, interesting and amusing phenomenon. That is, fortunately, it doesn't happen too often, but it happens often enough for us to have a chuckle. And that is, you have certain defendants hurl footwear at the judge. Okay. Now, if that happened and you, as a journalist, reported it, of course, the judge may not like it being reported, but if you reported it, you will still be protected because it is a fair and accurate report published contemporaneously of proceedings in a court of law. So that sort of thing. Okay? Yeah.
So there are many cases where very senior lawyers, they tell the judge on place that I don't expect a favorable verdict from you. I don't have faith in you to release the case. So this can be reported.
Yes, absolutely, absolutely. Actually, I'll just correct you very slightly. Even the most frank lawyer will never put it in those terms, in the way that you put it.
Maybe
Never. Absolutely, they will never say, I don't have faith in you. Okay? Usually they put it in extremely diplomatic language, saying the opposite. I have tremendous faith in you, my lord, but it will be good if it was heard by someone else. Okay? So that is the way it happens. But I take your point. Your point is, can an exchange of that sort be reported? And the answer is absolutely, no question about that. Okay? In fact, by coincidence, something like that happened last week in Bombay, and it led to a huge uproar where there was a case involving noise pollution in Bombay, which was being heard by a certain bench of the High Court. And when the case was called out, the government lawyer, because the case was against the government lawyer stood up and told the judges that the government was not very keen for the case to be heard by that bench. In particular, it was a bench of two judges. In particular, they did not like one of the judges. Of course, they didn't say they don't like the judge. They simply said, my lords, it would be better if this case was heard by a different bench. And the judge in question refused to recuse. That's a technical word, recuse themselves. So the judge said, I'm sorry, but I see no reason why this case should be taken out of this court. So I would like you to proceed, and I can assure you that I'll hear this case fairly. The government lawyer was not happy. So very soon thereafter, within a few minutes, they went to the court of the Chief Justice and made an application without giving notice to this judge. Made an application asking the Chief Justice to transfer the case from that bench to another court. The Chief Justice very shockingly allowed that application, and the case was transferred. That led to a huge furor, and there were all kinds of protests by lawyers, by bar associations, etc. And so much so that the case had to be transferred back to the original bench, all of which have been reported. Absolutely no problem at all. Because how else will the public know what's happening in the judiciary? These are very, very important matters. Because if a party in a litigation is allowed to choose its judges, then that will be the end of justice. Because we'll go to a favorable judge. And these are very, very important matters of public interest. So yes, absolutely no problems. Okay? But of course, when you are reporting, there should be no malice on the part of the reporter. So suppose a reporter has a grudge against a particular judge or a party, and then they give a spin to their story. Now that will not be covered. It has to be a fair and accurate and contemporaneous report of a judicial proceeding.
Sir, why contemporaneous is a matter of interest? Because I can refer back after 5 years that there had been a case and where such things happened.
It's also because it shows a degree of good faith, that you're not doing it with any ulterior motive, so that you don't make up something that happened 3 years ago, when a totally different situation has arisen in relation to a particular judge or a particular party.
Out of context reference should
Yeah,
not.
yeah, exactly. Okay. Now, postponement orders, I'm not going to spend too much time on this. What happens is sometimes a court may say, do not publish a report about this proceeding for a short time, for 1 week or 2 weeks, or till another case is heard, for legal reasons. When that order is made, then the media have to be careful. They have to respect such an order. But of course the difficulty is, sometimes the media don't know about the passing of such an order, because the order may not have been properly communicated, in which case the journalist should do everything possible to ascertain that such orders are in existence or not. And where no such order is passed, the press should not hesitate to report as normal. In other words, you should not assume that there is a prohibition against reporting. But at the same time, you take normal precautions. Find out, go to the court clerk and say, is there any order postponing reporting, etc. You don't have to do it, but if you're alerted to something, then you just take the normal precautions. Secrecy orders, now it's possible sometimes that the court may allow a name or other matter to be kept secret. So what the court might say is, we are hearing this case, but please don't reveal the name of, for example, a blackmail victim. In which case you will respect that order. You can report the case, but you don't name the person whose identity has to be kept secret. But as I told you, never can such an order be made about the identity of the judge. So a judge can't say, report everything you like except my name. That will never be allowed. And the press should not publish anything which will identify the person or matter. Scandalizing judges. Now this is the part which I think would be of particular interest to all of you, so I'm going to spend some time on this. What it means is that when you criticize a judge, you can criticize even in very strong language, but you should avoid attributing motives to a judge. In other words, you shouldn't do anything that is likely to shake public confidence in the judiciary. There is no single rule about when that threshold will be reached. So you'll have to take cases individually. But you can get some idea from decided cases, and I'm going to talk about decided cases under this head. In very general terms, the principle has been put in the following words: scurrilous abuse of a judge, qua judge, which means abuse of a judge as a judge, not as a human being, not as a person. So for example, if you are criticizing a judge on his personal life, that will not fall within this rule. It is only as a judge, what he is doing as a judge. And it has to be scurrilous abuse, not just criticism or of a court. And unwarranted attacks upon the integrity or impartiality of a judge or court would be prohibited under this rule. And even there's a lot of freedom given to the media, because in a free society, the judiciary is as much exposed to criticism, or should be exposed to criticism, as other branches of government. It's simply that you don't say or do things that will shake the public's confidence in the judiciary.
So, for some example, I want to know exactly was that in 2004. Chief Justice Keher's article was written about him after the triple talaq judgments. Like he's a bad judge and he only knows service law and etc. etc. Will that come? Will it resemble it?
I don't think so. I have not read the article, so it's very difficult for me to give you a definitive answer. But if now you used the phrase bad judge, now that worries me slightly.
So basically, the article said that how he should not be a Chief Justice also, because as he himself said in one of his Allahabad High Court judgments that I only know service matters, not judgment as such, in one of the interviews that I only know service matters, I don't know other matters. And so the
writer or the author of the paper basically questioned how such a person could be the Chief Justice.
Okay.
And how could be allowed to sit in the
Yeah, okay. Again, it depends on how it's worded, but generally speaking, without having read the article, my view is that that will not amount to contempt of court, because it's perfectly possible for someone to argue that a particular judge A made a grave error in the way that he gave judgment in a particular matter, and B, that he was not an expert in that area, that his expertise lay elsewhere, and that is probably the reason why he could not do as good a job as someone else who is an expert in the area could have done. Totally legitimate. But if on the other hand, the criticism was that this judge, this Chief Justice, gave the judgment because he took a bribe from the All India Muslim Personal Law Board or something like that, some such stupid, outrageous allegation, that would be contempt of court. Okay? So generally to say that the judge is not very competent would not amount to contempt. But to say that the judge is actuated by dishonest motives, that would be contempt. Even there are some caveats to be entered. So we'll look at this topic at some length now. And of course, this is a matter of very grave concern because this power has been used or abused in many jurisdictions in Asia, not just India, but many other countries, to suppress freedom of the press.
Sir, I don't know whether I'm right. My friends from the media will corroborate me. Generally, in ground rules, we generally do not criticize the judge. We may comment on the judgment, phase by phase, and pros and cons of the judgment, ramifications, implications, etc., whether any other cases are pending and it will be having an impact on other cases or impact on a public life, etc. Generally, sir, the training which we have is basically formal or informal. You can criticize the judgment but not the judge. That is the ground rule we follow.
Yeah.
Wanted to share.
Which is not a bad principle to follow, except that there may be occasions, few and far between, where you may have to criticize the judge also, because it is not only the content of a judgment that is worrying, but also the manner in which the judgment has been given. Sometimes, I'm not saying always, you're quite right, most of the time you can confine your criticism just to the judgment, but there may be occasions when you may have to criticize the judge. I'll give you a very tangible and unfortunately personal experience. Example. A few months ago, I wrote an article which has been published, which is now online, and you're welcome to read it if you want to. It was titled "The Perils of Judicial Impulsiveness." That's what the title was. It has appeared in many websites, but I think in India it has appeared in the website called Live Law, livelaw.com, livelaw.in or livelaw.com, I forget which. Now this was a direct attack on a particular judge of the Bombay High Court called Justice Gautam Patel. As it happens, he's a good friend of mine, and we were colleagues at the bar. So I have a lot of regard for him. So when I say an attack, I probably am overstating it. But it was, at the end of the day, you can't give a different word to it. You can't put a spin on it. It was an attack. I attacked him quite strongly because I believed that although he's a good man, he suffered from certain infirmities which have the potential to bring a bad name to the judiciary, and also in some respects to spoil his own record in the long run. Basically what I was trying to say was, he has a good intention when he passes some of these orders, but he is too impulsive, and I think I used the phrase, plays to the gallery. That's another of his infirmities. Now this is directly an attack on the judge, no question, it's not an attack on the judgments, although I did attack two of his judgments in the course of that article with good reason. I didn't simply say these judgments are bad. I said why they are wrong. Now, that is an example of an attack, as I said, on a judge, not on a judgment. And at least so far, nobody has slapped a contempt charge against me. And then this is not by any means the only example. I don't want to sound like a martyr or a hero. The issue is that there are many examples of judges being criticized and criticized very strongly. I actually would commend you to read some articles by a very good journalist also from Bombay called A.G. Nurani. Now Nurani writes extremely well about these matters, and he has written some articles going back 30 or 40 years on various judicial personalities. It is not uncommon, and of course in my part of the world it's very common for extremely frank assessments of judges. Nobody bats an eyelid. As long as you do it with competence, with integrity, in good faith, and also constructively. So your aim is not to destroy the judge, but also to show that there's a better way of doing things. In fact, if you read my article, I have been also very careful, both at the start and at the end of the article, to say, for example, that India needs judges of the caliber of Justice Patel. I genuinely believe that, except that he should correct some tendencies. And he's a relatively young man, so it happens sometimes at the start of your career, you want to get ahead. And you do things which you may not do if you are slightly more mature and if you are able to stand back. So yes, criticism of judges is acceptable, not just judgments.
So do you think it was a feat case to criticize Justice Karnan's behavior? I mean, we didn't...
Sorry, what case?
Justice Karnan behavior during those days.
Oh, of course, yes, absolutely. Oh yeah, no question about that. But the difficulty with that case is that it can backfire if you criticize, because that will actually be fodder to the fellow. It will only make it worse. You know, with him, probably it's a good idea to ignore him altogether. Which unfortunately the Supreme Court did not do.
Generally, we just reported the incident, not
Yeah, but there were plenty of articles which suggested that he was a madman, and that would be totally appropriate and justified. So, but as I said, the trouble is with such people, you are feeding the fellow's tendency to seek publicity. So better not give him the opportunity. Anyways, pulling his heels, I think, in a jail now. Maybe he's been released. I don't know. No, not yet. Okay, so there you are.
Doing some good work there.
Doing some good work where? In the jail. Oh, right, okay.
Teaching English.
Oh, right. Interesting. Right. And how do you get news
It's
of that?
reported in the media.
Oh, I see, okay. Has anybody interviewed him while he is in prison? No, not yet. Yes or no?
No.
Okay, alright. Because I'm sure you'd like to hold court while inside prison.
Let me share one secret to you as well as to the students and others. That media is most afraid of, if you measure the scales of afraid of police, afraid of administration or politics. Media, I know in this part of the world, I know especially in Kolkata, I can say, we are very afraid of the system which decides which is right or wrong.
You mean of contempt of court?
Yes.
Right.
Somehow or other, that's a big no-no.
In which case, I hope that this course is going to put a little bit of spine into a lot of journalists. You know, believe me, a lot of the time, such fears are misguided. You know, and unless you begin to push the boundaries, you are unlikely to at all make any headway here. Because fortunately, India does have a robust judiciary. It may be faulty, it may be creaky, but it still delivers. And the other good thing is the vibrancy of the Indian press. You know, if a judge tries to browbeat a journalist or bully a journalist, it will be found out very quickly, and it can backfire on the judge very badly as well. So, all those reasons I would say don't hesitate. I'm not therefore saying start attacks on judges without cause. You have to be very careful. I mean, at the end of the day, most judges are decent people, and therefore you should appreciate their predicament as well. And they function under very difficult conditions in India. So there is that. But when you find an example of somebody misbehaving, you should not hesitate to expose the misbehavior. You don't have to attack the person personally, but the misbehavior deserves to be brought to public attention. That's the point I would make. Okay, let's move on and talk a little bit more about scandalizing. So as I said, in many other Asian countries as well, this has been a problem, the issue of scandalizing judges. Okay, that takes us straight to the very important question. If you write something about a judge that might be seen as contemptuous, can you use truth as a defense to a contempt charge? In other words, you write something about a judge, the judge takes umbrage, the High Court issues a charge of contempt against you, you are hauled up before the court. Remember, you have a right to defend yourself. So when the time comes for you to defend yourself, can you say, yes, I wrote the article, and I stand by everything I wrote, I will prove that what I wrote is true? And the short answer to that question was, no, you could not. The Contempt of Courts Act in India did not allow truth to be as a defense, unlike defamation. Remember, in defamation, if you say something true, you can prove it and you can get away. But truth was not allowed as a defense under the Contempt of Courts Act until an amendment to the Act was introduced in 2006. Now, I will tell you the context of how the amendment came into being, and that is quite interesting. It arose out of this case of B.N. Kannade and Madhav Gadkari. As you can see, this is a case which started in the 1980s. Mr. Gadkari was a prominent journalist. He's now dead. He used to be the editor of Marathi newspaper in Bombay. And after he retired as editor, he wrote a column in the same newspaper. And this column was very widely read because he was seen as a man of learning, as a man of public concern, etc. And in one of the columns that he wrote, he commented on the state of the judiciary. He was very anguished by what was happening in the judiciary. And the article itself was therefore devoted to that theme. And in that particular column, he made 3 specific allegations about the judiciary. The first allegation was that he actually said explicitly that there is a certain judge in the Bombay High Court, he did not name the judge, there is a certain judge in the Bombay High Court who is susceptible to the charms of female advocates. Okay? It's a pretty serious charge to make against a judge if you think deeply about it. The second allegation he made was that there is another judge in the Bombay High Court, whose name also he did not reveal, who has the habit of threatening to switch off his hearing aid if he finds the arguments of lawyers tedious. So if a lawyer went on and spoke about something which the judge was trying to curb or curtail, and the lawyer did not heed and he went on arguing, the judge would say, look, you know what, I'm not going to switch off my hearing aid. Also, actually, if you think deeply, it's quite a serious charge against a judge. It might be amusing, but it's actually a serious charge. Basically, what it means is that the judge is not prepared to do justice, okay, or at least full justice. The third allegation he made was about a certain tribunal in Bombay called the Motor Accidents Claims Tribunal, MACT. Now, the Motor Accidents Claims Tribunal, as the name suggests, deals with cases involving compensation claims for victims of motor accidents. In other words, if you were run over by a car on a public street and you wanted to bring a claim for compensation against the driver of the car, the owner of the car, then you would go to the Motor Accidents Claims Tribunal. This tribunal apparently was located on the 3rd floor of a semi-dilapidated building in the center of Bombay. And apparently, the lift in that building was permanently non-functional. Just imagine, many motor accident victims wouldn't be able to walk. So it's a serious thing. But more seriously, what Mr. Gadkari said was that there was a practice in this tribunal under which, whenever any compensation was awarded, 1/3 of the compensation went to the victim 1/3 went to the victim's lawyer, and the other 1/3 went to the judge. Again, just see, very, very serious allegation. So he made these allegations in this article, which was widely read, it was published and widely read, at which point a contempt notice was slapped on him by the High Court, asking him why he should not be punished for what he said, because he had brought the judiciary into disrepute. He had shaken the public's faith in the judiciary. At which point, Mr. Gadkari quite unflappably responded to the notice by saying, yes, I did say that, I'm not denying what I said, and you know what, I'm going to prove the truth of everything I've said. Now this put the High Court in a dilemma, because nobody has ever been bold enough to say that. Most of the time people come and apologize and say, let me free. But not Mr. Gadkari. So he insisted on proving the truth of what he has said. Now there is a risk when this happens, because if you allow a contemner or an alleged contemner to prove the truth of such allegations, you are encouraging washing of dirty linen in public, because Mr. Gadkari will have to produce witnesses who will spill the beans. It will be even more damaging to the image of the judiciary when that happens. So the judiciary was very reluctant to allow him to do that. And fortunately for them, the Contempt of Courts Act did not permit truth as a defense. So the Bombay High Court, after hearing him, told him, sorry, we can't let you do that, and we are therefore sentencing you, we are convicting you on contempt, and I think they imposed a fine, I can't remember how many rupees, but whatever. And also I think there was a, then I'm not sure about this, but there may have been an order also for imprisonment for a very short time. Mr. Gadkari said, fine, if that is the case, luckily the Indian legal system allows me an appeal, so I'm going in appeal. He went to the Supreme Court of India by way of appeal. This is entitled, the Supreme Court immediately stayed the sentence, which means he didn't have to either pay the fine or go to jail. And the appeal was listed for hearing in due course. Now, the crucial thing in India is, of course, the phrase due course. So, nothing happened for many years. And Mr. Gadkari, of course, didn't have anything to lose, because he was out, he was doing his normal activities. But there was no sign of what was happening. And those of us who are interested in the development of media law were curious to know what is going to happen to this case, because it's quite an important case. So at one point I actually rang up Mr. Gadkari and asked him, can you tell me the state of your appeal? And he said, your guess is as good as mine. Which of course is a very truthful statement, because he himself did not know when his appeal is going to be heard. And so on and so on. It went on and on for years together. And unfortunately, on one occasion I read in the newspaper that Mr. Gadkari died. I presume that his appeal also would have died with him. We didn't hear anything about his appeal subsequently. But the good news is that there were some parliamentarians who took up this cause and said, we must do something about it. And they proposed an amendment to the Contempt of Courts Act, under which they allowed truth to be pleaded as a defense to a charge of contempt, but with the added proviso that when you plead truth, you also have to show a public interest. In other words, you just don't say, I will prove the truth and leave it at that, because if you did that, there's a risk that you may be able to prove certain private matters, matters of no great public interest about the judge or the legal system. So, if you are in a position to plead truth with the public interest, today you as journalists have the luxury of relying on the Contempt of Courts Act, the amended Contempt of Courts Act. So that is what the result of the Madhav Gadkari case was indirectly.
So the amendment has been effected?
Correct.
That means now
truth is a defense.
Is a defense.
Yeah. Along with the public interest.
Along with the public.
Okay? Right. Now, as I said, usually judges are willing to accept an apology if the contemner tenders such an apology in good faith. it is important that the apology is tendered in good faith. Now there was a case where what happened was a person was charged with contempt and he was given a hearing. He failed to satisfy the court that he should be discharged. So the court was about to convict him and said, we are going to punish you for contempt. At which point, the contemnor told the court, I'm sorry, I'm willing to tender an apology. So the court said, all right, even at this late stage, if you are willing to tender an apology, we'll accept it. Don't do it in future. What this fellow did was he was very happy to be let off. He went out of the courtroom, went outside the court building, and then made a public statement saying, you know what, I apologize only because I wanted to be let off. I don't believe a word of what I said. Right? Now, if you do that, the court has the power to call you back and say, okay, now you go to jail. So an apology has to be in good faith and genuine. So that's the principle concerning apologies. Innocent publication will not be punishable. For example, if you're the printer of a journal which carries a contemptuous article, then of course you can excuse yourself by proving that you are not in any way aware of the contemptuous nature of the article. Also protected are fair and accurate reports of judicial proceedings, which I have already referred to. Okay, I'll just give you a few examples from other countries, or including one in India actually, where you have examples from both sides. That is, those statements which have been held to be in contempt and those which have not. So the first statement is one where there was a finding of contempt. The article said that a particular judge was an impudent little man in horsehair. Horsehair being, of course, that we wear wigs in England. So every judge would be wigged, and the wig is made of horsehair. He was also called a microcosm of conceit and, sorry, that should be conceit, there's a spelling mistake there. Conceit and empty-headedness. This is what the newspaper said about the judge. That the judge was an empty-headed judge. Very strong words about a man who, rather ironically, was called Mr. Justice Darling. Another newspaper called another judge a bewigged puppet exhibiting a strong class bias. In other words, that he was inclined to side with rich people rather than poor people. And interestingly, the Indian case involved publication of a league table of judges. This was actually a publication called WA India. Now no more in existence. It's a defunct publication. I think published in Delhi. This magazine, whose editor at the time was Madhu Trehan, published a feature in which they tried to rank judges according to various attributes. Is this judge clever? Is this judge efficient? Is this judge punctual? Does this judge sleep while on the bench? Etc. etc. And they asked lawyers to give every judge a grade, a mark, and they published this league table. Now you can imagine the judges were not particularly pleased. At least the judges who got a low rank were not desperately pleased with this article. So the High Court slapped a charge of contempt against the magazine, and Madhu Trehan was hauled up for contempt. And she put her hands up immediately, said, very sorry, we won't do it again. She was let off. So that is an example from India. And I think on the whole that judgment is correct, because you cannot have league tables about judges. I mean, it's not very conducive to preserving the integrity or the dignity of the justice system. And then, of course, you have an opposite example of a statement which was held not to be in contempt. This is also an interesting example. There was a case involving a book called Spycatcher, about which some of you may have heard. I may have occasion to talk about Spycatcher in a different context later. When this book was published, it was published by a British Secret Service agent who had retired, and he gave his experiences while he was working for the Secret Service. And he took the precaution of first getting out of the UK and settling down in Australia before writing the book, before publishing the book. so the UK authorities will not have any jurisdiction over him. And when his book was published, there was a huge furor, the book was banned, and then it became very obvious that the ban was ineffective because the book was sold all over the world except in the UK. And of course people can bring books in and read and all that. So it became a bit of a farce. At which time, there was a court case in the UK involving that book. And when the judgment came, everybody thought the judges had pronounced an order which was unworkable. And the media were particularly unhappy with the verdict. So what they did was they criticized the judges, and one particular newspaper, a tabloid newspaper, had the photos of all three judges in the Court of Appeal put upside down as if they were hanging from a tree. It's a full page, huge splash on the front page, and the caption given was "You fools." That is, they're telling the judges, "You fools, what have you done?" In any other country, the judges would have been very upset and very angry and all that. But the judges did nothing, which completely deflated, I'm sure, the journalists. In any case, when they were asked, the judges said, "That's all right, we are very capable of taking criticism, we have broad shoulders." That's it. So that's the attitude sometimes judges take when they are criticized, and criticized so badly or so strongly. So there, that's another example of how very strong criticism is tolerated. And where allegations of corruption are involved, it may be advisable for the press to approach a higher authority before publishing the allegations. Very important. What happens here is this. Even if you are a crusader for probity in public life, and you have evidence, not evidence, you have information that a judge is corrupt, and the information is quite credible, you are dying to publish it. And it's understandable, you'll be doing a public service by publicizing such information. But it is still your duty, even if you have hard proof, it is still your duty before publishing to go to a higher authority with that information. Why? Because that is how these things are to be dealt with in a democracy. So you go to the Chief Justice, you present the evidence and say, "We have this information, would you please do something about it?" Now, it is possible that the Chief Justice may not do anything about it. Or, worse still, it is possible that the Chief Justice himself may be corrupt, in which case going to a higher authority would not particularly help you. In which case you still should think of other avenues to bring this alleged case of corruption to light. Only if all of those avenues are exhausted should you think of publishing the information. So exhaustion of remedies is a very important principle when it comes to dealing with judicial corruption or judicial misbehavior. Okay?
But sir, in this case, you're saying, so when journalist is going to the Chief Justice, with what purpose? I mean, I want a redressal of this complaint, or is it to, the Chief Justice may well tell me you cannot publish this, don't publish this.
Correct.
So what happens then? Why should I leave my work?
No, your aim is to A, have the corrupt judge investigated and punished. That would be your primary aim. I would imagine that that would be your aim even when you publish. Not something else, not to get personal glory. So that may be a side effect, right? But your essential aim, public interest aim, is to have the judge punished. In other words, to root out corruption in the judiciary. That's your objective. That objective can be achieved even without the article being published. For example, if he is a genuinely strict and upright Chief Justice, he may actually do something to ensure that this man is exposed internally, not publicly. In which case your purpose is achieved. But if you say, my purpose is to publicly expose a judge, then of course going to the Chief Justice may not achieve that purpose. So it depends on what you have in mind. But if you say, I want to expose the Chief Justice and I don't care, I want to expose the judge, I don't care what the Chief Justice says, I'm going to publish, then you take the risk of yourself being in contempt for publishing something of that sort.
Also, when writing about a judge, the thing we always do. The person who is accused, we try to reach out and seek a comment. So how do we do that in case of a judge? Because as I told you yesterday, most judges don't talk.
Yeah. Okay. You can do it in this way, that you have every right to approach the office of the judge. Not the judge personally, but the office of the judge. Every judge has what we call a private office, that is a secretary or some sort of other officer. And generally speaking, nowadays courts also have public relations officers or registrars. Okay, so you go to them and you say, it depends. Now sometimes you may actually want to have a conversation with the judge. Believe me, judges are not completely unwilling to talk to outsiders. They are actually very willing, many of them. So what you have to do is, you have to seek an appointment in the normal way. You can't intimidate them, but you can request an appointment. And especially because you're dealing with a sensitive matter, you don't want to discuss the corruption thing with the secretary even. So you say, this is a very confidential issue which I want to discuss with the judge. And you seek an appointment. Now, if you are rebuffed, then you can bring that fact to the attention of the Chief Justice. You said, look, I actually did try to get an appointment with the judge. I was not allowed to. So at least you did your job.
But sir, what my friend has mentioned is not on the trial itself, not on the court proceedings of the judgment. What we understand, please correct me if you are wrong, that we cannot, the judges cannot interpret the order which he has pronounced once.
Correct.
Is it correct?
Absolutely.
So
Yes.
then I cannot go for clarification.
No. We are talking about a situation
That's
where
a different situation.
you have an allegation
Right,
about
I fully agree.
wrongdoing on the part of the
That
judge.
I have no problem.
Yeah.
What I am saying that regarding a judgment,
You cannot seek clarifications.
Yeah.
No. You will only have to go by what is in the judgment. You make the most of it. You can consult lawyers, ask them for their opinion of what the judge has said. Yeah, that's fine. There's no problem at all. I'm talking about judicial corruption and judicial misbehavior. Okay? So that's how you should be dealing with those cases. I'm going to now run through a few examples. Almost all of them in India. The first big contempt case in India came in 1970 and it involved Namudripad, who I'm sure you're all familiar with, used to be a communist leader. Now what this man did was he addressed a press conference in the course of which he said, judges are guided and dominated by class hatred, class interests and class prejudices, and where the evidence is balanced between a well-dressed, pot-bellied rich man and a poor, ill-dressed and illiterate person, the judge instinctively favors the former. Just see, in a sense, you couldn't expect Namudripad to say something else because he was a communist. So he was quite consistent in the way that he characterized judges, but it is extremely destructive of the independence of the judiciary, because what you are alleging is that, and he says all judges, he doesn't say some judges, that means judges as a class are biased, which is the worst thing you can say about a judge. And the judiciary is part of the class rule of the ruling class. The judiciary is weighted against workers, peasants and other sections of the working classes, and the law and system of judiciary essentially serve the exploiting classes. Classic statement by a communist. And not surprisingly, this immediately invited a contempt charge. And Mr. Namudripad was given the opportunity of defending himself. He had no defense. He probably, to his credit, said, look, this is what I genuinely believe in, and why should I not say what I believe in? Except that the law does not allow him to make such statements, so he was duly convicted of contempt of court. But, bizarrely, the punishment awarded was a fine of 50 rupees. Now, I know that 50 rupees was more valuable in 1970 than it is now, but still, it was, many people thought, an unsuitable punishment. So that is the Namudripad case. Then you have the case involving a judge in Karnataka and the Hindu. What happened in this particular case was that some of you may remember a few years ago there was a scandal involving judges of the Karnataka High Court. The scandal consisted essentially of a report that these judges en masse, many of them, not all, but many of them, went to a resort in Mysore, which is supposed close to Bangalore, where the High Court is, and spent a weekend in the company of certain female advocates. The judges were all male, female advocates, and of course, I'm putting this very mildly, the actual reports spoke of an orgy over the weekend. Now this is a very worrying thing if it happened. And of course the newspapermen would have checked their facts and they were able to give a lot of information about who were the participants in the, shall we say, the party. The upshot of it was that the judges in question slapped a charge of contempt against the newspapers, against the journalists, which I would imagine most of you would agree is quite wrong. Why? If you agree, why do you think it's wrong?
It should have been defamation.
Correct. If the newspapers had falsely reported about this, what they call the orgy, then the judges could easily have sued the newspapers for defamation, the journalists for defamation. They did not. They used the charge of contempt. And the judges decided to ensure that the journalists presented themselves to face proceedings for contempt. Except that because there was such a huge furor about all this, I think that the charges were eventually dropped. But this is actually a case where, again, I want to reinforce the point of the difference between contempt and defamation. It is an ever-present threat, this threat of contempt, in certain circumstances. But luckily, again, there was a national outrage over this incident, and therefore the media, the journalists, did not suffer any punishment. Then there was a case from Bombay which involved a little known Marathi paper. And here the context was that there was a spiritual attack on a former judge at the Bombay High Court called Sri Krishna. And what the article in question said was that this judge has become insane. He is more poisonous than a snake or cyanide. He is affected by bias and motivated by a desire to get beneficial postings after retirement. Very strong stuff against the judge. And why did the newspaper say all this? Because Justice Sri Krishna had chaired a commission of inquiry to go into the Bombay riots. There were some Hindu-Muslim riots in Bombay. And this newspaper, the owner of this newspaper, was a very staunch Hindu supporter, Hindu nationalist. And they thought that Sri Krishna was too soft on the Muslims, and therefore they had a sort of a grudge against it. So they kept writing editorial after editorial attacking me. What I've given is just a sample of what they said. They said much worse things. The articles were in Marathi, and I think I also remember one particular telling phrase they used about Justice Sri Krishna. They called him a monkey. So that's a tone and tenor of these articles, which of course was totally unacceptable, because you can criticize the judge's action, but you don't indulge in personal abuse of that sort. So the High Court charged the editor of the newspaper and his daughter, who was, I think, the managing editor or the executive editor. They charged them with contempt. And when they were hauled up before the court, the father and daughter both said, we stand by every word we have written and we have no desire to apologize. The court said, will you please apologize, we'll let you off. He said, no, we are delighted to stand by everything you've said, and therefore do your worst. In other words, issue a challenge to the court. The court said, all right, if that is your stand, then we will have to punish you. And the court decided to sentence the daughter to 1 week's imprisonment. The father they exempted because he was very old. They just slapped a fine on him. And That was it. So this is an example of the media behaving irresponsibly. They could still have criticized Justice Sri Krishna, but not in the way they did. So there's a lesson there. You can attack a judge for what he does, but you don't attack him in these crude personal ways. So that's an example of where the media was actually at the receiving end of punishment.
So what you meant by the court on it, so it's a suo motu or?
Correct. It's a suo motu contempt charge, yeah.
So how is this contempt of court, sir? I believe Justice Sri Krishna was a part of the committee. I mean, there was not court from committee, something like that.
Yeah.
So how is
In fact, you're right. Actually, that also became an issue in this case, whether it is contempt to criticize a retired judge of the court. And I think they ruled in this case that the ramifications of the article went beyond Mr. Sri Krishna and reflected on the judiciary as a whole. I think that was the basis on which this case proceeded. Arundhati Roy, I'm sure you're familiar with. For reasons of time, I'm not going to spend too much time on this. Basically, she was engaged in a mission at one point of very severe criticism of the judiciary, made worse by the fact that she accused the judiciary of being completely biased, etc. Now, a lot of people have argued in the context of this case that the judiciary played into her hands by charging her with contempt because she became a bit of a martyr, and that the judiciary should have simply ignored what she said. She was punished by imprisonment for 1 day, which she suffered very gladly and came out with more grandstanding statements. So whether it's right or wrong is a debatable issue, but the fact is that what she said was clearly very dicey in terms of contempt law, because you don't, unless you have, as I said, either strong evidence or approach the higher authorities, make allegations of such generalized bias against the judiciary. But then, of course, coming as she does from a certain position, ideologically, it's not surprising that she said what she said. Another case which involved a lawyer from Madras who had questioned the right of the then Chief Justice of India, Mr. Anand, to continue in office. Because I don't know if you are aware or if you remember, there was a controversy over Mr. Anand's age. It's a very sad state of affairs when a judge's age is called into question. In other words, the judge says that he was born on a certain date, which turns out from other records to be a year or so later than the date on which he was actually born. And this happened also, as you know, to a former chief of army staff. People want an extra year of service, right? So they try these kind of things. In the case of Mr. Anand, various investigations were made, and there seemed to be a consensus on the part of some of the investigators that there was credible information that he was fudging his date of birth. Mr. Ram Jethmalani, I think, went to great lengths to find the truth. And one of the things he did was he went to the Inns of Court in England, where Anand was a student many decades ago. Anand, I think, wanted to train as a barrister, so he went to, I think it was Lincoln's Inn, and they tried to get, Mr. Jethmalani tried to get his records from the inn to show what he declared there. And it turned out, according to Mr. Jethmalani, that the age he had shown there was different from the age he had shown in India. But then in the process, something else happened. Mr. Jethmalani got hold of his mark sheet, which also had his date of birth, and it turns out that his academic record was pretty pathetic. So in a sense, you know, indirectly, something else got exposed. But anyway, that's not relevant to our discussion. The issue here was Mr. Sundaram, a lawyer, sent a telegram to the Chief Justice saying that he should resign on the grounds that he had passed his aid of superannuation, which was what was in dispute, followed by criminal complaint of breach of trust, cheating, criminal breach of trust, etc., for usurping the office of CGI. Now, obviously, Mr. Sundaram was a bit obsessed. That is becoming quite clear. The question was, did what he do, or what he did, amount to contempt? And this was held to, this was held as amounting to contempt because what was found was that he had meant to malign, undermine the dignity and authority of the Supreme Court, and he was therefore sentenced to 6 months imprisonment. But of course, the point that was raised in the context of the conviction of Mr. Sundaram was that there was a tremendous amount of inconsistency in the manner in which this law has been applied. So you have, for example, Mr. Jetmalani saying things himself which were pretty strong. So he said in his book, it has been my misfortune to discover in the present Chief Justice of India, that is again he's referring to Anand, an unpardonable degree of conceit and self-righteousness. Pretty strong stuff against the judge. Another person who was a former law minister, no less, Shiv Shankar, saying that the Supreme Court is composed of the element from the elite class. Now, of course, his English is not particularly strong, so you'll have to make allowances for that. Of the element from the elite class and their unconcealed sympathy for the haves, i.e. the zamindars, antisocial elements, that is Dera violators, I presume it means foreign exchange. What is Dera? Farah, I could understand. It could have been Farah. Bride burners and a whole horde of reactionaries found their heavens to court. Again, very strong stuff. Basically, he is saying in different words what Namboodiripad had said. Not very different at all. He's saying basically that the Supreme Court judges favor all these people. Yet nothing was done. And what is particularly interesting is that he made all these observations at a speech in the Bar Council of Hyderabad. So he made it responsibly fully aware of the consequences of what he's saying, and yet nothing was done. So inconsistency is also a feature of the application of contempt of court law.
So then we understand that contrary to defamation, where a publication was a prime concern, here me writing a letter to justice denigrating him will amount to contempt, we understand.
Which is itself a very debatable issue. Should not. I think, I'm not 100% sure about the full.
Here there was no publication in
No, that's what I'm coming to. I think Mr. Sundaram, in addition to sending his telegram, also publicized it in the press. So there was
He had also filed an FIR.
Yes.
He had gone ahead and filed an FIR.
Correct. And that would have been publicized
yes.
as well. Exactly. So it's not simply writing a letter, but in any case, if he has done something that is reasonable in terms of engaging the law, then I would imagine that that should not be taken as an aggravating factor. So anyway,
individual letter may not be.
May not, but you know, it's very difficult because some judges, because of their egos, could do anything. I personally think that the law of contempt has been, at the very least, inconsistently applied. And I would also suggest that it has been on occasion applied in circumstances where the judges should have simply ignored what was said. But that's personal opinion.
Or it was applied differently to people of different positions.
Absolutely, that's inconsistency I was talking about, yeah. Then a couple of other cases. This was a case from Madhya Pradesh, where there was a news report in the local big newspaper indicating that SAIL was a public interest litigant. He had turned the decision of the High Court, acquitting certain persons earlier who had been convicted of murder as rubbish, and insinuating that one of the judges had been bribed. Now, the second part is certainly worrying. The first part, to say that the judgment is rubbish, is, I think, something which should be taken as innocuous. And the editor, etc., were left off with the caution and the reporter excused on the ground that he was a novice, but SAIL was given 1 week's imprisonment. So again, probably to make a point, he was sent to jail. Yes, the allegation is serious that the judge had been bribed. And this was 2005, which was 1 year before the amendment to the Contempt of Courts Act coming to being. So I suspect if it had happened after the amendment, Mr. SAIL would probably have said, okay, let me prove that what I said is true. In which case, he would probably have been given the opportunity of using that defense. The other case was 2007. There was an application to the Supreme Court that the existing Chief Justice was incapable, corrupt, and worthless, and that judges were inefficient, incompetent, and bribe takers. So I don't know when he says judges were, is he referring to particular judges or all the judges, difficult to make out. And this was held to be contempt, and it resulted in a 2-month term of imprisonment. Now, obviously, this is very strong stuff, and when you make these allegations, then you have to accept a degree of risk. Special reporting restrictions. Now, one of the things I've already spoken to you about is that if there is a rape case, then of course you wouldn't be wise to reveal the identities of rape victims, because that is covered by statute to be kept confidential. It would be contempt to reveal the identities of children involved in legal proceedings, also as a matter of public policy. And of course, the other point about children is jigsaw identification. You should be careful. What happens here is this. The order, or it may not even be an order, it may be a statutory provision, simply says do not identify children. But what if one newspaper gave the name of the school from which the child came without revealing the child's name? Another newspaper did not give the school or the child's name, but gave the area from which the child came. And a third newspaper gave another detail about the child. It's perfectly possible for intelligent readers to piece together the identity of the child. That is an ever-present danger. Now, each of the newspapers is not in contempt, but taken together, the identification is complete. How do you deal with this situation? The way it works in other countries is that there is an understanding among editors that they will not do anything that will amount to jigsaw identification. This only happens if there's cooperation between sections of the media. And of course, in some countries, the law allows the identification of rape victims, provided certain conditions are satisfied. I can tell you the position in the UK. The law allows a rape victim to be identified, first of all, if the rape victim herself comes out and says, I want to be identified. And why would they do that? They will do that sometimes because they want to start a campaign against rape. For example, rape in the workplace. And they're willing to let their names go. But then there are conditions attached to that. If a rape victim wants herself to be identified, she has to give her permission in writing and under circumstances where she satisfies the court that she has not been under any pressure or under any inducement. So if all those conditions are satisfied, then a rape victim can allow her name to go forward. The other possibility is when the police need witnesses to come forward for a rape because they're carrying on investigation, they haven't yet nabbed the rapist. Now in those circumstances, for jogging the memory of witnesses, the police may, with the consent of the rape victim, allow the name to go forward, because that's the only way they can then get people to talk about what they may have seen at the time of the rape. So those are sort of examples of how identification of rape victims may be allowed. And care should be taken while reporting divorce and other similar cases. If there are salacious details about a divorce case, then obviously those will be excluded. Also in some cases, names are anonymized. So you don't give out the real names of the parties involved in a messy divorce proceeding. It will be content to publish proceedings involving national security secret processes, about which I've already spoken, where the court has indicated the need for secrecy.
So in case of non-in-camera matrimonial cases,
yes,
there is no bar in reporting to me?
No. Although I've seen a tendency on the part of Indian newspapers almost always to change names. I don't know why, because I cannot see a public policy reason for doing that. But they almost do it reflexively. There it is. I don't think it's a matter of great concern, but it is something which struck me as slightly odd. But on the other hand, it is not necessarily unique, because if you read a newspaper in a country like the UAE, every crime case will result in news reports only carrying the initials of the parties involved. Every crime case, even if it's an innocuous traffic offense, they will never publish the name of the defendant. Again, I don't know why. It's a cultural thing, I think. So that's all right. I mean, if you have a practice, then you can stick to it. I will also tell you my experience in Bhutan, your neighbor. There's a different reason why they are a little squeamish about identifying crime defendants. They say that even if there is a serious crime, newspapers tend to avoid naming the defendant until they are actually convicted. So if they're not convicted, of course, their names will never come out. And the reason apparently is that there is a tremendous amount of shame attached, which creates problems for the family. So that if somebody in the family is accused of some crime, then the family suffers. And therefore, as a cultural reason, they do not, the newspapers, the media do not report the names of defendants or accused persons. Now, the argument against it is that there are certain occasions when you need to name and shame the accused. And it is tough luck that the family also gets identified. So that's a matter for debate. I mean, you can have your views on it. But that is how things happen in various countries. Interviews with witnesses, I think I already mentioned this to you. It could be risky to publish interviews carried out with with potential witnesses in criminal trials, particularly if there is any doubt about identity, etc. Pictures, very important. Don't underestimate the difficulties that pictures present in relation to contempt. It's not only words. Sometimes you may publish a picture, say of a potential defendant or an accused person whose identity is in doubt, and this can amount to contempt as well, because it can pervert the course of justice or interfere with the administration of justice. Okay, a few other cases. I'm not going to deal with all of them, particularly because we are coming very close to the end of our time. You know what, I will... Okay, I've already told you about the first case, so I'll skip that. The second one is interesting. There was a rumor one day that a certain judge's home was being raided by the CBI. Now you know what it means. There's obviously a suspicion of corruption. So, this chap from the Hindustan Times, when he heard the rumor, he took the precaution of phoning the judge's home and asking if the rumor was true. This must have happened in the morning, and he wanted to publish something in the edition for the next day. So by evening he wanted some information. And he was constantly fobbed off. I think he would have said, can I speak to Justice Anand, who was the judge involved. Not the Anand I spoke about earlier, but different Anand. And he was not given access to either the judge or to any information about the raid. In which case what he did was go ahead and publish the story, but being very careful to say that these are just rumors, that I have tried to get confirmation but have been unsuccessful. And the next thing that happens is he's slapped with a contempt case. Do you think that's right? Why not? Sorry?
Actually, he has written nothing against judiciary, he has written something on the child person.
Correct. That's one of the reasons why a contempt charge would be inappropriate in these circumstances.
And he believes guilty.
Exactly. Even if there was a case of defamation, he could have used the Brennan's defense and said he acted responsibly. So you can see an abuse of the contempt of court law. Okay, I'll come just down to that second last case, the Tanzania reporters case, which has to do with the question one of you asked me 2 days ago. What happens if you as a media person go to a court and you take notes and the judge says, sorry, I won't let you take notes? This is not a hypothetical situation. It has happened many times, and it happened in Bombay as well. Because judges sometimes tend to be very arrogant. and they don't like any activity that they think should not take place. So this is what happened in this particular case. Now, the unequivocal answer to any such prevention would be that there is no business to stop you from taking notes. As long as you do it unobtrusively. In other words, you don't disturb proceedings in court. You don't have a very scratchy pen which makes a lot of noise, or you don't do anything else that is likely to interfere with the proceedings, then you have every right to take down notes. So if that happens, what I would suggest, and it is possible that I'm being a little idealistic in the Indian context, is that the reporter should respectfully challenge the order of the court. First of all, by telling the judge that he did not think that the order was right, and secondly, very politely in diplomatic language asking the judge for the legal basis for the prohibition. Now I know that it is not easy, and it can lead to more trouble for the journalist, but that is exactly what should happen. One of the sad things is the reporter may not always get the support of his employer, because this is where I think the problem is. If the employer was willing to stand by the reporter, the judge can be brought to heel very quickly. And it is expensive, because what may be required is an appeal to a division bench of the High Court, or to the High Court if it happens in a lower court. How many people are willing to do it? And I don't blame the reporter, because at the end of the day, if the reporter is not supported by his employer, then there's only so much that the reporter can do. But remember it as a point of principle that there is no reason why anybody should be prohibited from taking down notes. It is a different matter if you use a tape recorder. That is not allowed. Okay, there the judge would be entirely right. When I say a tape recorder, I also include a mobile phone, because as you know, a mobile phone nowadays can record everything that goes on around you. So as long as it's taking down notes in the old-fashioned way, there should be no prohibition against that at all. Okay. Any questions? Okay, the last case is not a case strictly for the media, but I brought it because it's another amusing case, but also it's a case which illustrates the need for the law of contempt to be used with mercy. And what happened in this particular case was that there was a young man, this is an English case, a young man who was training to become a solicitor. Now when you train to become a solicitor, you have to serve a period of apprenticeship. In other words, you follow a senior lawyer around the courts for a couple of years. Very boring stuff, but you have to do it. So this boy, I call him a boy, he's a young man, was obviously quite bored with what he had to do. So he decided one day that he wanted to bring a little bit of amusement to his life. So what he thought of doing was to introduce, through the air conditioning system of the courtroom, laughing gas. So he, on a certain evening, he decided to climb up the roof of the courthouse after the court had closed, and take a canister of laughing gas and put it there in the air conditioning duct, knowing that the next morning, when the court assembled, that will filter down to the courtroom. And of course, you can imagine the consequences. The chap was climbing up the roof when he was stopped by a security guard, and the guard asked him, "What are you doing?" And very truthfully, the man said, "Sorry, but I was trying to just inject a sense of humor into the court. I was just thinking of putting this laughing gas up there." He was duly brought before the judge the next day, and the case went on. It went quite high up in the judiciary. And what the judges did was, now of course it is clearly contempt in the sense that it would have interfered with the course of justice. No question about that. Not through words which are published, but through other means. Because remember, I showed you what the wording of the Contempt of Courts Act is. So it would have interfered with justice. But what the judges said was, yes, we appreciate that this is a clear case of contempt, but justice has to be tempered with mercy. So we know why you did it. You didn't do it with any bad intention, but for God's sake, don't attempt it again. We'll let you off. So that's again an example of how a judge should treat these kinds of cases. I suspect an unhumorous Indian judge would have taken a very pompous attitude towards this person and made all kinds of bombastic statements. R.K. Anand and Delhi High Court. R.K. Anand, okay, this is a different Anand. There's so many Anands featuring in these cases. This chap, he was a lawyer who was handling remember the Sanjeev Nanda hit and run case. And this fellow, quite frankly, was trying to bribe a witness to ensure that his client was not convicted. And there was a sting operation by, I think, NDTV, as a result of which Mr. Anand's misdeeds were exposed, and a contempt charge was sought to be slapped against the channel. And when the matter was taken to court, it was held that that NDTV was justified in telecasting the film even before the trial of the case had ended, because there was a strong public interest involved in exposing corruption and perverting the course of justice. The next case, again, I'm going to skip, nothing of consequence there. Confidentiality of sources is the last thing I want to talk about. Now, you know that there is an ethical duty on the part of journalists not to reveal confidential sources. So if you give your word to a source that you're not going to reveal their names or identities, then you have a moral duty, an ethical duty to keep that confidentiality. But Indian law does not give journalists the right to withhold their identity of the sources. This is a very clear example of a clash between ethics and law. It happens in other areas as well. So on the one hand, ethics requires you to keep your sources confidential, but law requires you to reveal the sources if asked to do so, not on your own. But if a court orders you to reveal your sources, you can't say to the court, but it is my ethical duty to conceal my source, and therefore I won't give you the information. So in a sense, you have a moral dilemma. You have a dilemma whether you are going to reveal the source or not, whether you're going to be true to the source or whether you're going to be true to the law. There are many journalists who have been very willing to suffer punishment because they think ethics is more important. Some years ago, you might have read in the newspapers about a New York Times journalist, a lady who went to jail, I think, for 3 months or something, simply because she refused to give the name of a confidential source. So it's a matter of personal choice.
Sir, that means it's not only in India, in many other
Absolutely.
countries.
And the UK as well. Yeah.
Is there any country where this is protected for the journalists?
Okay, there is up to a point in the UK. You are not required to reveal your sources except in the interest. I'll come to that slide in a minute. I'll explain to you. But I'm just sticking with India. Interestingly, under the Press Council Act, which Press Council, remember, does not deal largely or exclusively with legal regulation. It's more ethical regulation. Journalists cannot be compelled to reveal the sources in proceedings under that law, but in proceedings under the Press Council of India Act. That is to say, enquiries which are carried out under the Press Council of India Act. You know that it's possible for somebody to complain to the Press Council about, for example, inaccuracy or any other ethical misdemeanor on the part of a journalist. Now, when those proceedings are launched, then the journalist concerned need not reveal his source. But that's for a very limited purpose. So that's what the section is. It's also not permissible for a journalist facing a libel suit to be compelled to disclose his source of information pending the trial. This is a technical matter. I don't want to spend too much time on this. This was in a case from Bombay in 1987. Now I want to go and wrap up by talking about what I just said. In the UK, what happened was that this whole issue of journalist confidential sources was raked up and the case went right to the European Court of Human Rights. And there, the verdict was that the UK Contempt of Courts Act was faulty, because the UK Contempt of Courts Act, before its amendment, was like the Indian Contempt of Courts Act, exactly the same. That there was no right for the journalist to keep his sources secret. So, because the European Court ruling, the UK Parliament was required to change the law, and so the UK Parliament amended its Contempt of Court Act. And now the position is that no court can require a person to disclose on pain of contempt the source of information contained in the publication for which is responsible, unless, this is a qualifying part of the section, disclosure is necessary in the interest of justice or national security or for the prevention of disorder or crime. It's only in those three circumstances can a journalist be compelled to disclose their source. If these circumstances don't exist, then you are allowed to keep your sources confidential. Of course, the NUJ, the National Union of Journalists, which is the largest professional body of journalists in the UK, their code states that a journalist shall protect confidential sources. So again, that principle is affirmed on the ethical side by the code that applies to journalists. Use of recording devices, I've already told you about this, that it should be contempt to carry and use any recording device in court, and that continues to be the position in India as elsewhere. But sometimes a judge may give permission to use the tape recorder as an aid memoir. In other words, not for publication, not for broadcasting, but only for your own memory purposes. Now, this will be particularly true of people who suffer from disabilities. And use of mobile phones inside a courtroom will also amount to contempt. Very, very important. If you start using a phone inside a courtroom and it starts ringing, it would definitely be contempt. Any disruptive behavior can also be punished as a contempt. Tweeting in court. Now, this doesn't apply to India, but it may happen in India. I'm giving this only because any of you who wants to start a reform campaign might want to note this. There has been a relaxation of the rules about tweeting in many jurisdictions, including in England, where what has now happened is that the public are allowed to use live text-based communications during court proceedings after seeking permission from the court. So if you want to tweet from inside the court, particularly in a case that is of great public interest, you can take permission from the court. You can use a mobile phone for tweeting, as long as it is very silently done. And journalists can use such communication without permission. So difference is made between public and journalists, and permission may be denied exceptionally. For example, in a criminal trial, where there's a risk of future evidence being contaminated. In a criminal trial, there's a risk, because if you tweet something or send a message out, then another witness who is sitting outside may get wind of it, and his evidence may be contaminated. Any unobtrusive handheld silent piece of modern equipment will be allowed. So again, there are qualifications. And even within the UK, there are slight differences in the three jurisdictions that we have: England and Wales, Scotland, and Northern Ireland. But generally speaking, nowadays tweeting is being accepted. Broadcasting of court proceedings, very rare. In America it is, so many of you may have seen, for example, the trial of O.J. Simpson, which was telecast in such a big way. And of course, it's usually confined to civil cases and appeals rather than criminal trials. The risk about telecasting proceedings is that lawyers, judges, witnesses can play to the gallery, and that is not a good thing for justice, among other things. And sometimes witnesses are intimidated by the presence of cameras. And some courts allow for recording all court proceedings, but not their broadcast. And of course, our Supreme Court actually does allow for internet streaming of proceedings. So one of the best examples I'll give you of proceedings which particularly the law students here might want to watch, and I would commend you to watch it, are the 4 days of hearing of the Brexit case. Absolutely fascinating stuff. It's on YouTube. You just type in UK Supreme Court Brexit and you'll get it. Absolutely wonderful. It's all done very soberly, very nicely. So it has its advantages, but it's not widespread. So there we are. For a change, I've been able to go through all the slides and still only exceed my time limit by about a couple of minutes. So I'm going to stop here. Any questions? If not, you can bring your questions tomorrow, because I can see a certain desperation on the part of some of you to want to leave the room. You're very welcome to. See you tomorrow.